Hi, I'm Mandy Fitzsimmons. I'm your Washington REALTORS Legal Hotline Lawyer. And today we're going to talk about the survival clause. Doesn't that sound fun? The survival clause is found in the Financing Contingency Addendum Form 22A. There is survival language. The word survival is actually used in the language that I'm talking about in the bottom part of the first section of Form 22A. So what does the survival clause mean? Well, let me give you a fact pattern because this is a fairly common fact pattern. Now, in this fact pattern, you have to assume that the buyer has a Form 22A, Paragraph 2, Option A, financing contingency. And if you're familiar with the form, you know exactly what that means. What that means is that buyer has a financing contingency that never, ever expires by its own terms. The only way that financing contingency ever goes away is if seller delivers the notice to perform and in response, buyer waives the financing contingency. Candidly, most listing brokers don't tell their sellers to deliver or give them the notice of their opportunity to deliver a notice to perform. And so most sellers allow a buyer to go all the way through the closing date with that Paragraph 2, Option A, financing contingency, protecting buyer's interest in the transaction, giving buyer the legal excuse to terminate the contract. That's what the financing contingency does. That's what any contingency does. It gives the buyer the legal excuse to avoid performance of the contract. So in this fact pattern, where buyer has the financing contingency all the way through the closing date, buyer has made a good faith effort to obtain financing and believes they're on track to obtain financing. And at the closing table, buyer's financing fails for some reason. Every buyer has a different reason. And just because it fails at the closing table does not mean buyer engaged in bad faith. There are plenty of good faith reasons why the financing is suddenly unavailable at the closing table. So let's assume in this fact pattern, that's what's happened. Buyer made a good faith effort, but notwithstanding that good faith effort, buyer's financing failed at the closing table. And so buyer delivered notice that buyer would be unable to close and claimed the protection of the financing contingency after the closing date. And after the closing date, where the sale failed, buyer also delivers the Financing Contingency Form 22A, Paragraph 4 letter from buyer's lender. This letter is a requirement of buyer being able to collect the earnest money under the financing contingency. So let's say that after the closing date has passed, buyer delivers the notice that financing failed and also delivers a proper lender letter. It covers all of the three requirements: the date of loan application, that buyer had sufficient funds to close the transaction, and identifies the good faith reason that buyer was unable to close the transaction. That letter gets delivered to seller, but it gets delivered after the closing date. The question is buyer's earnest money nevertheless protected, even though buyer did not give notice prior to the closing date? And the answer is yes. Buyer's earnest money is still protected. Why? Because the survival language in Form 22A, Paragraph 1, means that buyer's financing contingency survives a sale fail. So even if the sale fails and all other terms of the contract are now gone because the contract is void, it's expired, they're gone, the buyer's financing contingency survives. If seller never delivered the notice to perform and never forced buyer to waive the financing contingency prior to closing, then buyer's Form 22A, Paragraph 2, Option A, financing contingency survives beyond the failure of the transaction to close. And even if it's a day after, a week after, a month after, you get where we're going, a year after, there's no limit on this survival clause itself. There's no deadline on the survival clause. It simply says that the buyer's financing contingency survives closing. So even if the buyer's lender letter comes much, much later, buyer remains entitled to collect the earnest money. Buyer's obligation to close the transaction can be excused even weeks or months after the sale failed closing date because of the survival provision. If you have questions on this issue or any other, please ask a question by visiting warealtor.org. Thank you for being a Washington REALTORS member.